Yes, Mr. Block.
Lord, before we adjourned, the question was raised, I think, by my Lord Reid, what the position of the United Kingdom government might be. And of course, we don't have a brief in relation to this case.
Yes.
But we do have a brief submitted to the Supreme Court of the United States in Hoffman-La Roche. And one finds that in the Authorities Bundle, Volume 11. It's the brief of the United Kingdom, Great Britain, Northern Ireland, and the Kingdom of the Netherlands in support of the petitioners, and the issue there related to the long-arm jurisdiction of the United States antitrust laws. The most pertinent part of the brief is at MS 11509, where the argument is summarized. The United Kingdom, Ireland and Northern Ireland, as well as the European Community, vigorously enforce their competition laws and reserve their harshest penalties for domestic and international horizontal cartels, which fix prices, allocate markets, restrict output, and rig bids. These enforcement systems rely on international coordination and continued respect for the values and judgments reflected in each nation's process. And then you see from the heading immediately beneath that, the direction of travel of that brief.
Yep.
Before we adjourned, I said that FRAND is imbued with territorially specific values and that the judge was right to see that. I'm not sure that one needs to expand on that greatly, but one could, for example, compare Article 2 of the UKSC statutes, which is, I'm not inviting you to go to it, at Appendix 9, 109, 3063 at MS 3536, with Article 1 of the China Communications Standards Association, which sets out the objectives in relation to China and the interests of the public, which it is endeavored to serve, which in the context is the public in China. One finds that at Appendix 9, 3355, MS 3828. The UKSC undertaking is a contractual undertaking. However, the content of the undertaking is informed by the role it plays in UKSC policy, and indeed the role that it has been thought appropriate for it to play by the Commission, both insofar as the Commission was there at its origin, and also as one sees from the communication which you were taken to by Mr. Howard, which sets out not simply an analysis of what UKSC FRAND is, but what the Commission thinks is the appropriate way to approach, among other things, licensing and the negotiation of licenses. And I note in that context in particular the box in section 2.4, which one finds at A8, tab 148, at MS 9547. So there is, we would submit, a strong case for restraint that's been developed by my learned friend Mr. Howard. One also sees it developed in the Apple intervention, in particular by reference to the United States approach. And, my lords, my lady, you have been taken to the case of Apple and Qualcomm, and also, I think, to the decision of the US District Court for the Eastern District of Texas in the Optis and Huawei case, examples where the United States courts have declined to extend their jurisdiction as they saw it in relation to matters concerning foreign FRAND and foreign antitrust, in recognition of the fact that the laws of other countries in relation to such matters differ from their own. So one may ask, how is it that the English court feels compelled to determine global licenses, and the American courts feel it would be wrong to do so. One reason why the English court didn't see a problem is because of the language in which FRAND is couched. The Court of Appeal in the Unwired Planet case saw the reasonableness inherent in FRAND as a reason why the decision of the court could not be overreaching. At paragraph 117, in Core 2 at 39 MS 512, the Court of Appeal in Unwired stated, "It is important to have well in mind that the global license settled by the judge is FRAND. There is nothing unfair or unreasonable about its terms. The assumption is if it's FRAND, it is ex hypothesi reasonable." What that, of course, fails to take into account is that what is reasonable according to one standard of reasonableness may not be reasonable according to another. Now, whilst there are a significant number of issues of principle with which we are grappling in this case, it is also necessary to have regard to the reasoning of the Court of Appeal, the judgment of Lord Justice Floyd. And what I propose to do is to go through that in order to identify the basis on which it was held that this is really a patent case, and to also identify why it is that no further thought or consideration was given to the question of what the convenient forum conveniens was. So if one starts with the judgment, which one finds in Core 2 at page 77, MS 550, I think I can start with paragraph 10. Paragraph 10 of the judgment, the court notes that as far as the FRAND negotiations between the parties were concerned, the discussions had been on a global basis and have not focused or indeed referred to the UK as a market or the UK patents in suit. So no one would have characterized the dispute as especially connected with this country before Conversant issued proceedings. At paragraph 17, one sees ZTE's offer, which I will come back to when considering the way in which that was addressed by the judge. And at paragraphs 20 and 21, my Lords, my Lady will note the relief which Conversant is seeking. This is, of course, relevant to the question of what the claim or claims to be considered is or are, and we address that in our written statement of case, in particular at paragraphs 7 to 11 and 13 to 15. The initial approach of the Court of Appeal to the question of characterization begins at paragraph 32, where the Court of Appeal accepted that the case is not restricted to an analysis of the claim and relief sought by the claimant. One must have regard to the totality of the dispute, and of course there is no argument as to that. One can then go to paragraph 95 on page 573, where the Court of Appeal recognized that a critical initial question is how the dispute is properly to be characterized. And in paragraph 96, it states one must look at the overall dispute between the parties. It's to be noted that up to this point in the judgment, the Court of Appeal has not identified any basis on which to decide whether it is a FRAND claim or it is the patent claims which characterize the dispute. The basis on which the Court of Appeal concludes that the case is a patent case begins at paragraph 96 of the judgment. And one sees in paragraph 96, it stated, the dispute characterized as a whole still involves the question of essentiality, infringement, and validity of the UK patents. The commercial dispute, which was referred to in paragraph 10 of the judgment, it involved a multi-territorial patent portfolio and its licensing. The commercial dispute referred to in paragraph 10 was not focused on the UK patents. Implicit in the approach of the Court of Appeal is a focus on the dispute as the claimant has framed it for the purposes of the jurisdiction in which the claimant has chosen to bring it. When the Court of Appeal states that the dispute involves specific questions relating to UK patents, the Court of Appeal is simply looking at the proceedings as brought in this country. However, that is but a first step to the basis on which the Court of Appeal endorses the judge's approach. A critical next step in the Court of Appeal's reasoning is at paragraph 97. There it is stated, to define the dispute in so general a way that the claimant is left to pursue a claim based on a different property right and different underlying facts in the foreign forum is likely to define it too broadly. That's not the end of the analysis. What is being said in paragraph 97 is a question of what's likely to be the case. The Court of Appeal goes on in paragraph 98 and subsequently to see whether that is correct in this case. So in paragraph 98, the Court of Appeal looks at the way that the claims were analysed in the Unwired Planet case. The content of the undertaking and the type of negotiations which would be consistent with it are defined by reference to what is necessary to protect the parties. And that's something which I will need to come back to when considering the content of FRAND and how one establishes it. In paragraph 98.2, one sees an aspect of the undertaking is derived from what was necessary in order to protect implementers. And in paragraph 98.3, an aspect of the undertaking is derived from what was necessary to protect SEP owners. However, the thing to note for present purposes is that there is nothing in this analysis to assist in deciding whether the declaration as to FRAND or the declaration as to infringement provides the appropriate characterization of the dispute. The critical reasoning one finds in paragraph 99, where the court states that the content of conversant's FRAND undertaking is thus an inseparable part of the dispute about whether conversant is entitled to relief for infringement or the infringement of valid UK patents. This is the critical reasoning, and we say that this reasoning is incomplete. First, of course, it was inaccurate immediately before the commencement of the proceedings. Second, and more importantly, if and insofar as the essentiality, infringement, or validity of the UK patents might have any effect on the terms of a global license or the amount payable under it, the patent issues may equally well be seen as an inseparable part of the FRAND claim. The distinction between claims and issues, which is implicit in the Court of Appeal's reasoning, is not capable of distinguishing one of those perspectives from the other. In paragraph 101, the Court of Appeal states, leaving conversant to seek a remedy in China would be to compel them to advance a case based on different patents. However, this, we say, is not quite accurate. FRAND disputes and patent validity disputes fall within the jurisdiction of different courts in China. The same is true in Germany. And in fact, Conversant took the position at first instance in this case that it could advance its FRAND claim in this country without it establishing any patent rights in this country. The Court of Appeal's analysis presupposes that the dispute is a patent dispute rather than a licensing dispute. It does not advance the argument as to whether or not that is correct. With that in mind, one can go back to the nature of the FRAND claim itself. And one sees that touched upon in paragraph 110 of the judgment at page 104, MS 577. There, the Court of Appeal acknowledges that the claim for a declaration as to the terms of the FRAND license might be regarded as a separate claim. But the Court of Appeal states, on the basis that Conversant does not seek the declaration if no UK patent is found to be valid and essential, the declaration is better regarded as a dependent claim. Now, quite what's meant by a dependent claim is not entirely clear, but first, it is tolerably clear that the Court of Appeal would not have held the English court was the proper place to bring the FRAND claim if that were all that Conversant was claiming. Accordingly, one may ask how it becomes a proper claim to bring in this country simply by virtue of it being also a dependent claim to a patent claim. The answer one finds is at paragraph 104 of the judgment. If one characterizes the case in the way in which I have shown that the Court of Appeal did, it is said the forum conveniens question answers itself. And indeed, it does appear that that's the view the Court of Appeal took, because the Court of Appeal didn't go on to consider the matter further. In particular, the Court of Appeal did not consider the offers which Huawei and ZTE had made to facilitate the resolution of the FRAND dispute in China. Now, my lords, you have seen the offers. ZTE is set out at paragraph 17 at page 81, MS 554. And my lords also looked this morning at what the Court of Appeal said at paragraph 122 of its judgment at 580, when it was dealing with the question of the admission of further Chinese law, to the extent that the further evidence shows that the Chinese courts will entertain issues concerning FRAND royalties for non-Chinese patents with the consent of both parties, it goes no further than the findings that the judge made on the evidence before him. So one sees from that the way in which the judgment of Mr. Justice Carr was interpreted by the Court of Appeal. That
must mean that it doesn't enable the Court of Appeal to reach any more confident conclusion than Mr. Justice Carr reached, mustn't it? It's not saying the Chinese courts will entertain jurisdiction.
No, it can go. It simply shows the way in which the Court of Appeal was viewing the findings of Mr. Justice Carr, and what I will endeavour to persuade my lords of is the fact that that is the correct way of viewing it. If one turns to the relevant passages from his judgment, which are at MS 859, page 386 in the hard copy bundles, what one sees...
Sorry, could you give me the MS number?
859.
Thank you.
859.
Thank you.
859. What one sees is, first of all, in paragraph 61 of the judgment, he is dealing with what can be done without agreement from both parties. So what he finds there is he's not satisfied that that a global FRAND determination can be made by the Chinese courts without agreement from both parties. In paragraph 62, he then goes on to consider the offers that were made to Conversant and whether or not it was reasonable for Conversant to reject those offers. The offers that were made were offers to have a global determination in China. And I will look at the particular reasons that he gives when one looks more closely at the offers. But for present purposes, the important thing to note is that he does not say that the Chinese courts would not carry out a global approach. What he says is that it would be unfair, and one will look at in detail at his reasons for rejecting the offer. He doesn't reject the offer on the basis that the Chinese courts could not determine a global license. He rejects the offer on other grounds. And if it were that he thought that the Chinese courts could not have determined a global license, he would no doubt have said so.
Well, he did say so in paragraph 61, or at least he said that the evidence that they might was tentative and speculative.
Well,
I thought 62 was, as it were, an alternative approach if he wasn't right about that point.
well, the obvious thing for him to have said in 62, if he thought that that was a determinative basis, was that the offers would not work. And the grounds that he provides for saying that the offers were not reasonable are other than that. So we say that on a fair reading of his judgment as a whole, he was envisaging that with the agreement of the parties, the Chinese courts would make a determination, albeit, we see, according to different law. And if one then goes on and looks at the basis on which the judge rejected the offers, one can start, I think, with, well, I think the first point one has to make, of course, is that the judge found at paragraph 63 of his judgment that he would reject any submission that Conversant would not obtain justice according to Chinese law.
No, but the very first reason, which in 62.1, he says, Conversant's made it clear that it does not accept the defendant's offers for a number of reasons which in my judgment are reasonable, and the first one is the fact that rates are lower in China.
Precisely, my lord.
And as you explained before the short adjournment, it looks as though China has made a decision to have the relatively low rates for social and economic reasons, which is an exercise of sovereignty.
My lord, indeed, and just jumping ahead, I should clarify, we do not say that it was unreasonable of Conversant to decline to have a global determination in China. What we say it was unreasonable was for Conversant to insist on a global determination anywhere other than China.
Mm-hmm.
So we're not suggesting that they were obliged to have a determination under Chinese law, and we accept the judge's finding as to what the consequences of that would be.
Yeah.
But we said they had a choice.
Yes, but if China has decided that royalty rates should be low in order to bring the cost of the technology within the reach of ordinary people in China, whose incomes are going to be lower than ordinary people in the West, that's an exercise of their sovereignty over an immunity, over a monopoly granted by China. And if one has that on the one hand, and Conversant's right to decline to accept Chinese royalty rates because they're economically disadvantageous to the patent holder, then the inability, well, the fact that the holder of a Chinese patent is enabled via the English courts to undermine Chinese policy is a reason for questioning the validity of the exercise that's being undertaken.
My Lord,
Which is Mr. Howard's point.
Yes.
When he says that effectively he's saying that it's a mistake to look at industry practice of granting global portfolios because that's not what Clause 6.1 is actually about. It's not about global portfolios.
My Lord is absolutely right, of course, and if that point finds favour with you, it is an answer to the problems in this case.
Just on what is being said in 62.1, maybe I've got the wrong end of the stick, but is Mr. Justice Burse, as quoted there, not saying that because royalty rates are lower in China than the rest of the world, that he would reduce the amount that for Chinese royalties in the global license? I might have got the wrong end of the stick, but that's what I thought his reference to a factor of 50% was.
I believe, my Lord, that what he is considering in 62.1 is whether or not it was reasonable for Conversant to decline the offer that was made to Conversant to have a global determination.
No, sorry, this
China.
is Mr. Justice Burse in Unwired Planet.
Oh, sorry. I apologise.
Yeah,
Yes.
no, not at all.
Yes.
He's not seeking to say it's a good reason to refuse China because you'll get a higher Chinese royalty rate in England. He's talking about the consequences for the entire portfolio in other parts of the world than China.
Indeed. My Lord, let me put the point again, because I accept that. If you have a determination of a global license in China, on these findings, you will end up with lower rates, both in relation to China and in relation to other jurisdictions.
Yes. He's not suggesting that it's a good reason that you end up with lower rates in China, but he's suggesting because the Chinese courts would apply Chinese law to the whole exercise,
Absolutely.
that you would get lower rates elsewhere in the world.
Indeed. But that, in fact, is no different from the English courts applying English law in relation to other jurisdictions. It may or may not be that under the English practice adjustments are made, but there is in fact a symmetry. You get a certain set of rates if you go to China. You get a different set of rates if you proceed in this country.
But
So the only answer is to confine each country to its own.
There are two ways through. One is the one that has been urged upon you by Mr. Howard, and if it succeeds, that is an answer. But if that doesn't succeed, it's not the end of the matter, and that's why I'm endeavouring to develop a separate argument. Because what we say is that where there are such alternatives, it may be perfectly reasonable for the SEP owner to seek a global license where a global license is available. But what is not reasonable is for it to do so in a jurisdiction which has no substantial connection with the real underlying dispute. So we say that there is an option, insofar as global licensing can be done at all through the courts, but that when it comes to the exercise of that option, one asks not simply, is it possible, but is the choice of jurisdiction the appropriate one, or is it the reasonable one? And we say you get there because of what it is that is being judged here, which is FRAND, which has to be fair, reasonable, and non-discriminatory, not only in its outcome, but also in the process.
Can I just ask one very basic question? I'm sure there's a simple answer. If it wasn't hung on a patent dispute, could a party come to this court and ask for a FRAND determination, either locally or globally?
If locally, on the face of it, what one would be asking for is a declaration concerning the meaning, effect, or application of a foreign contract, and subject to considerations of justiciability and comity, the court would, in the ordinary way, be able to address it, and also in the ordinary way would consider questions of foreign convenience. Now, if insofar as it would involve the determination of matters going to the validity of patents, or so closely akin thereto that issues of justiciability and policy arise, then the answer would be that one would not do so. But that goes back to the argument that has already been advanced by my learned friend. What we say is that there's a further argument, even if that ultimately doesn't commend it to you, and that is based on the process which FRAND involves. Because it's not simply the outcome with which we're concerned, we are concerned with the way in which the parties go about seeking to establish the terms on which licenses will be granted. So if it were the case that for one reason or another the parties had been focusing all their attention on a particular jurisdiction and the patents of that jurisdiction, and that was the center of the commercial dispute, in the event that there are not justiciability issues or other policy issues akin thereto, it might be perfectly reasonable for a SEP owner to say, I want the court to deal with all the outstanding issues. It could be that the outstanding issues did not even concern the validity of patents, but simply went to value. As a matter of principle, that could be the case, and it might, for example, in particular be the case if one was dealing with a license covering not the world, but the EEA or the EU, where at least the competition issues would be aligned. So what we say you need to ask in every case is whether or not the process which the SEP owner is pursuing, not just in its negotiations, but in what it is seeking from a particular court, is itself in accordance with FRAND. And what we would say is that just in the same way as we've seen from cases such as the Huawei and ZTE case, that there are requirements as to the way in which you negotiate, so there may also be requirements as to what you might seek in any particular proceedings. And at its simplest, if what you wish to seek is a global license or a multi-territorial license, you must turn to an appropriate court in which to seek it. And we say that this court, the English court, the court in which the patents that will be in suit have not even been considered in the negotiation, a court in a territory which represents 0.07% of my client's business, and a court which is singularly ill-fitted to deal with questions of Chinese patent law and Chinese competition law, even if there is not a justiciability issue, is not the court in which it is reasonable to seek that relief. So even if one gets over the justiciability hurdle, we say there is still a further issue that arises, and we say that it would arise even if we are wrong in what we say about the judge's findings as to what could be done by the Chinese courts. Because whilst it is perfectly true that in the event that the Chinese courts could not determine a global license on that hypothesis, there still would be fora rather than a single forum in which those outstanding issues could be dealt with. And we would say on the basis of VTB and the underlying principles in Spiliada that for these purposes, that would be a sufficient way of resolving the dispute between the parties, even if it meant that there needed to be more than one set of proceedings, because the alternative would be that the determination of the license would be being sought in a jurisdiction in which it was not FRAND for the SEP owner to pursue it. Now, so far as the forum issues are concerned, you have been referred by Mr. Howard to the Vedanta case, and I'm not sure there's anything else that I need to say in relation to that, save that I would observe, I may be repeating what was said before, that it's the threat of duplication is one that arises anyway by virtue of the German proceedings, and in a case in which the real dispute were to be found to be in China, it's the risk of inconsistency should not be a sufficient basis on which to hold that the whole matter should proceed here. Finally, then, one comes to the question of case management, and plainly, in a sense, case management may arise in the course of the case, and it may be said to me, well, these are submissions that can be made in due course in the case, although plainly the appropriate orders to make depend very much on the issues which are before this court, and the line between a forum conveniens stay and a stay by way of case management at the outset of a case may be a fine one.
Well, is it that fine from the perspective of the party who, if his claim is stayed for forum conveniens reasons, has his original permission to serve out set aside so that he can't bring the other party before the court at all, even for the purposes of the discussion about case management?
My Lord is, of course, correct that in the discussion will have taken place in coming to the decision in relation to forum. The same issues will have been raised in arguing whether or not permission to serve out was properly given. But formally, it is right, the court won't have the party before it in the same way as it would if it gave leave to serve out. As a matter of substance, though, we would say the argument will be essentially the same. So, in relation to case management, I think we have referred to the Reichhold Norway and Goldman Sachs case, which, in view of the time, I won't go to. I don't think you've been taken to that. It's at A3 tab 56. In that case, the issue was whether or not, as Mr. Pollock submitted, a plaintiff was no longer entitled to exercise unfettered control over the conduct of proceedings, even when they had been commenced in this country as of right. And Lord Bingham Cornhill accepted that that was no longer the case. And if one looks at the facts of this case, on the assumption that there were to be ongoing proceedings in China as between Conversant and ZTE, as a practical matter, not only would the Chinese proceedings resolve the issue as regards China, if we are right, it could also resolve the issue or issues as regards the rest of the world if Conversant wished it to. And whether or not it resolved issues in relation to the rest of the world, it will have resolved a very substantial issue concerning China and the manufacturing of all the products which are sold throughout the world, so that the resolution of that dispute would undoubtedly lead to a license and thereby render the resolution of any outstanding dispute in relation to the UK patents moot. So as a practical matter, if the action were to continue or there were to be an action in China, and it resolved these matters in relation to China in favor of Conversant, there would be a license, and that license would render the pursuit of any claim in this country quite academic. So from a case management point of view, we would submit that this is a case, such as the Reichhold Norway and Goldman Sachs case, where there is a separate route which would enable the SEP owner in this case, the claimant in that, to obtain justice in a speedy and efficient manner. And the alternative if my learned friend Mr. Howard is right, is of course the English court will fall in line with the American courts and the other courts whose jurisprudence you have been taken to, and there isn't a problem. But if my lords reject that, then as things stand, and on the reasoning of the Court of Appeal, this court will have to take every case. There will be no basis on which one can distinguish between cases on a forum convenience basis, and there will be no scope for controlling that by way of case management. Now, that we would submit is a very unsatisfactory result, and it would also be a surprising one, given that what we are dealing with is a concept of reasonable conduct, or which involves reasonable conduct, not just as to the outcome, as to the license, that is, but also as to the process. And by way of final observation, I would submit that the seeking of relief from the court and the relief that is sought from the court is as open to assessment as to its reasonableness and its compliance with the ETSI undertaking as any other aspect of the behaviour of the parties so that whilst the court could approach the question of the content of FRAND and the course that it will take in relation to FRAND cases separately, in fact, one can approach it as one and the same issue, because the court is seeking to find a reasonable way through what otherwise would appear to be a conundrum. And what FRAND requires is that the parties should act reasonably. Lords, unless I can assist you further.
Thank you very much, Mr. Blower. Mr. Speck.
This case is about technology developed in an industry that has adopted standard setting as its modus operandi. Part of this appeal is the issue as to whether schemes that apply to such cases, in this case you know it's the ETSI scheme, it being a mobile telephone case, there are others, whether those schemes enable parties in a dispute over the use of SEPs and a dispute over what are FRAND terms to have that dispute resolved. Or can one party, the implementer, insist that the other bring proceedings in each and every country which there's patent protection, or even have to sue on each and every patent in each and every country? That country-by-country approach, as I shall explain, is simply not practicable, and indeed Huawei's own witness accepted that. And be it under no illusion, it would basically mean patent owners would be left without payment. And moreover, implementers and their customers would be left without the license that they need. Moreover, the trial judge found that real-life commercial people would view country by country as madness. And we've seen that referred to in our case, and I think my friend sought to address it yesterday. It's a finding in his judgment in Court Volume 2, Para 543 on MS 748. And it's the first half of that paragraph. See the judge's conclusion about halfway through that paragraph as to what real willing licensor and licensees would conclude. Madness. Yet, it's that madness that my friend contends for. He cannot challenge the finding that the scenario is in fact madness, and as I understood his arguments yesterday, he was really just suggesting, well, that's what comes with patent litigation. In fact, my friend's arguments, when analysed, he's contending for an even greater madness, as, in fact, he doesn't adopt an argument that is directed to a country-by-country approach at all. The central focus of his arguments are, in fact, that it's a patent-by-patent approach. And in fact, the central focus of his arguments is the new contention that remedies for standard essential patents should be limited to damages. Injunctions are inappropriate. that is not only greater madness because it's patent by patent, it actually involves no license at all. No license at all. So all the patents remain unlicensed forever. Even when the standard essential patent owner does sue in respect of them. Now, my learned friend suggests, and I'll just give you the reference, this is para 138 of Huawei's printed case, Core 1 MS229, that declining an injunction and ordering damages in lieu is the court legalising in advance that which would otherwise be a wrongful act. That is quite wrong. It's simply declining to enforce the law. It's still a wrongful act. And perhaps one of the more striking things about his argument is that he's also relying upon Huawei and ZTE. Even though, as my lords and my lady know, that he's undertaken to take the FRAN licence that emerges after this appeal regardless, so the injunction should be irrelevant, he still relies upon it. And one of the things that we can all agree about, Huawei and ZTE is a case about bringing claims for injunctive relief on SEPs. There's a dispute between the parties as to precisely what it does, but that's what it's about. And my lords and my lady may be forgiven for wondering, why was the short answer from the CJEU in that case not, why are you asking us about proceedings for an injunction for a SEP? SEP claims should be limited to damages. So the point I'm making, of course, is that this new damages-only argument is wholly inconsistent with Huawei and ZTE and the whole rationale of the jurisprudence that one sees there. And another striking thing about my friend's case is that one way or another, his jurisdiction arguments are all attempts to avoid the true effect of the carefully balanced contractual framework that each industry body has constructed. Not only are his arguments advanced to achieve that end, his arguments actually rely upon the true meaning and effect as the premise for it. It is because the true meaning and effect of the ETSI-FRAND undertaking in the Unwired Planet case is for a global licence that my friend argues there's no jurisdiction. My friend also, and this has really only cropped up in his reply to this, says that there's a difference between consensual FRAND and FRAND which results after proceedings. That is an argument that there is a two-tier system. It discriminates against truly willing licensees who enter FRAND licenses consensually. Moreover, because what he's arguing for is a position where, on the court side of his FRAND dichotomy, it's disadvantageous to patent owners, it will actually encourage more and more implementers to hold out and reject a consensually determined FRAND license. That is also contrary to the underlying rationale we see in cases such as Huawei and ZTE, which is to encourage parties rapidly to conclude a license by agreement on terms that reflect commercial practices in the field in question. That is key. And as I shall explain, that does not involve determining validity or infringement of specific patents. Ultimately, it is simply a factual exercise in assessing value that real people in the commercial world would carry out. And you see that, for instance, if you look at the trial judge, Mr. Justice Burse, I'm now in Core 2, MS679, it's para 170. At the top of MS679, what you actually see there is not just that that's the exercise, but it was common ground. Just to pick up on a point that looked as if it was troubling my Lord Reed a very short while ago. The point about China in Mr. Justice Burse's exercise is that he looked at the rates that were being agreed and had come out of China, and he dealt with it. And so in Mr. Justice Burse's licence, we had a 50% Chinese rate, and the disputing conversant that I think my Lord Sales picked up on was what would have happened in China is we'd have got the lower rate for the rest of the world.
Yeah. What I found more surprising was his conclusion that China would not be a suitable forum for determining global FRAND rates because the effect of their applying their own law was to apply lower rates than would be applied by a British court.
Not for China.
Well, I thought that was...
I'm going to come to it.
Yes.
I was just trying to explain.
I read the paragraph as saying that the Chinese courts would apply their own law to the whole issue.
Yes, that's the point. That's the point I was just making.
Yeah.
And they weren't a suitable court to carry out that exercise because it would result in a lower figure than a British court would arrive at.
But for sales outside.
For sales outside
Yes.
China.
For sales outside, well, because a British court would apply the local law of each country in question.
Yeah.
Rather than
Well,
our law.
exactly. Well, the British court would see that in real life licences you're getting a lower rate in China, and that's what.
Yeah, and if in another country you've got a higher rate, well, they'd factor that in as well.
Indeed.
Yes, I mean, the British court looks at the comparables and sees different rates being allocated to different jurisdictions. It doesn't look into Chinese law or German law. It simply looks at the figures.
Exactly.
Yeah.
But the underlying policy that causes lower Chinese rates is reflected in that.
Yes.
And that's the point I'm making. I am going to come to the offer and so forth. I just thought that there might have been a misapprehension in some of the questions that my Lord asked, but Mr. Justice Burse was applying the Chinese rate, as it were, to China, but not elsewhere. And the dispute that you were looking at was the fact that China would apply the Chinese rate everywhere.
Yes, and it was because it would, apparently, that Mr. Justice Henry Carr concluded that it wasn't an available alternative forum.
Well, not only because of that, that was one of many factors. In fact, paragraph 61 is much more important.
He talks about applying Chinese law to the whole ETSI or FRAND issue. Literally interpreted, it looks as if he's saying they'd even apply Chinese law to the interpretation of the ETSI undertaking. Did the evidence go that far?
I'm not sure about the evidence. There is a point on that, on the digital case that went on. We understand that that's relatively recently been set aside by the Supreme Court.
Okay.
Because I thought I'd seen a letter that had asked them to draw that to my Lord's attention. I don't want to be too categorical about it because I don't have it to hand, but I think that's Can I also say this? Payment of royalties under a global FRAND licence is not, as my friend suggests, the price for access to the UK market. That, if I may say so, rather portrays the outlook of a party holding out, considering everywhere else is available to it for free. The royalties under the global FRAND licence are the price for participation in the international scheme which develops and supports the international standards and the markets that are supported by them, and includes the patent owner's internationally effective undertakings. That is what the price is. It's for access to that. And the national injunction is a consequence of seeking to participate in that scheme without taking the licence. And it just so happens that it's the consequence of the first place where you've been held to infringe without a licence. The price, you don't pay the extra price if you're also infringing in France the next week. It isn't a price for access to the United Kingdom. My learned friends like to portray it as that, but it's not. Now, with those rather high-level introductory comments, can I say this? There's a division of labour on our side, and so Ms Ford will deal with issues 3 and 4, and my job is issues 1 and 2. And the way I propose to proceed is follows. First, I want to take a little bit of time to make sure you have a grasp on some of the key issues to do with standard setting and the patent landscape. That includes practical issues and how the dynamic in litigating over a set portfolio differs from the ordinary case. And it also involves making sure you've got a good handle on hold up and hold out. I'm going to turn to issue 1, and I'm going to start with the straightforward answer and some key points that I want you to keep in mind. I'm going to call them propositions for want of a better label. Most are exactly that, but others are flagging up big picture points, such as points that are inherent in my friend's case that I want you to keep an eye on. Next, I'm going to turn to the detail of the specifics of issue 1 and how it's put, and in particular how I understand it's still maintained in the reply case. Then I'm going to tackle the foreign law and the comity issue head on. That is quite a chunky section of my submissions, and that's because when you see the cases, you will see that they're actually strongly against my friends. There are many jurisdictions where injunctions are granted. There are jurisdictions where injunctions are granted on the back of the fact that the patentee has made a global license. Sorry about that. Once I've done the foreign law, I'm going to address my friend's attempt to go back and re-argue the true meaning of the ETSI undertaking. That, I think, as my lords and my lady have understood, is neither within the scope of the agreed issues before this court, nor is it anything but a question of fact in the United Kingdom courts. And most seriously, he's running an argument as to the true meaning and effect of the French law contractual undertaking, this time saying it's patent by patent. So it's actually a contention not even advanced before the judge. And after that, I'm going to turn to issue 2. So can I just say a few words about standardisation? It's generally recognised as a good thing. And you'll have seen Lord Kitchen explained why this is so in para 3 of his judgment. I'll give you the reference. I don't think we need to turn it up. It's page 12 in Core Volume 2. That's MS 485. And he explains there that it supports innovation and growth by ensuring interoperability. And that means you can buy a Huawei phone or a ZTE phone or an Apple phone, and they all work in an area, say, fitted up with Ericsson infrastructure. And still in the matters covered by Lord Kitchen in paragraph 3, that leads to an increase in the range and volume of products meeting the standard, and it allows consumers to switch more easily between products from different manufacturers. So if you don't like your Huawei phone, you want an Apple one, you go and buy it and it still works the same way. And what that means is manufacturers are competing in markets for interoperable apparatus. And that is exactly the way Mr. Justice Burse characterised it. Again, I'll give you the reference. Don't ask you to turn it up now, but it's para 83 of his judgment on MS 658. In fact, it's the bit bridging the page, 658 and 659. And so what one has with standardization is this creation of what one might think of a universe of technology. And it's made available to those willing to take a FRAND license. Within that universe of technology, they can make and sell apparatus in competition with others in that universe. And the universe of technology and the markets in the apparatus made in accordance with it is international. Now, the way in which it's international needs a little bit more explanation. First, and obviously, the markets are international because manufacturers make products anywhere in the world, and they can ship them anywhere and sell them anywhere. And what that gives you as the public is increased choice. Phones made by US manufacturers, Chinese, Korean, Finnish, and so forth, all good to go all round the world. So the global public have the increased choice. And you benefit from the economies of scale because manufacturers can make products intended for those global markets, created and supported by the global standards. But they're international in another way, an important way. Devices themselves are intended to be capable of being used by consumers as they move around. So all our devices work when we go abroad. And that gives rise to the roaming issue that I'll come back to. Let me move on and consider the actual process of developing standards. It's an absolutely huge collaborative exercise in innovation. And again, it's international. Talking about a large number of participants from around the world being engaged in the process over an extended period of time. The result is each generation of new technology will be a very significant improvement over the previous. It's packed full of innovation. Now, the process itself is facilitated by standard-setting organisations. They bring the participants together, set up working groups, committees and so forth. They organise the meetings where technical proposals are submitted, discussed and debated, and where decisions are made. And there are 2 points I particularly want to draw attention to. First, the investment is huge, and consequently the number of inventions involved is very substantial. You have some idea of the scale of it, for example, from the kinds of figures you've seen in Qualcomm's intervention. It's one of the largest, to be sure, but they are but one amongst many substantial contributors. And you'll have seen the figures for them, just them, $5 billion a year, 60 billion overall. That's paragraph 3 of their intervention. So when we come on to considering the ability to secure fair recompense, it's recompense to provide incentive to that kind of investment. And contrary to the impression given in some of my friends' submissions yesterday, we're often concerned with portfolios much bigger than those involved here. We're not talking about having one patent here, one in China, one in the US, or however he put it. It's not unrealistic to consider a portfolio to have hundreds and hundreds in individual countries, tens of thousands worldwide. The second point I make is that unlike non-standard cases, where the basic aim of traders is to avoid others' inventions, in this situation, the whole point of the process, the standard setting process, is to make everyone's inventions converge in the same practical products and apparatus. The purpose is not to avoid taking each other's inventions, precisely the opposite. The whole idea is everyone takes the whole shooting match. Wholesale international use is precisely the point. Get that when you consider an argument from my friend that there are, in effect, should be entitled to do that for free, save to the extent that patentees can secure payment in respect of the odd individual national patent that it's practicable for a patentee to enforce. That's what he's arguing for. Now, my lords and my lady know that a key issue for those setting up these standard setting regimes is how to provide fair recompense for those that carry out the huge investment needed to create that universe of technology within which those manufacturers compete. It's a very serious point, because the whole rationale of the standard setting exercise is to set that universe up. And as I've said, that will involve wholesale international use of a vast number of patents. And it's impossible to contemplate suing individually in respect of each individual patent or each individual country. I asked Mr. Cheng, Huawei's Vice President for IP licensing, about this. And we've given you a key passage at paragraph 130 of our written case. It's worth just having a look at that. It's Core Volume 1, MS 330. The passage I'm actually talking to you about is paragraph 130, but in fact appears just below another extract at para 129 of the written case. That's relevant to what I'm talking about at the moment as well. In the earlier evidence, higher up, he expresses the view that the patent in suit approach was an unreasonable one for a potential licensee to demand. And we particularly draw attention to that because, of course, that was in fact Huawei's stance in the litigation for 2.5 years until the matter of days before the Fran trial. And it is in fact the logical conclusion of nearly every argument. In fact, I think it is every argument that my learned friend put before this court. So the upshot is that Huawei know and accept that it's not practicable to approach licensing in the context we're addressing by requiring either patent by patent, or when you look at the second quote, even country by country litigation. Now that is important to the phenomenon of hold up and hold out and return. Now, back to the balance that those responsible for the system are considering, at the same time as wanting fair recompense, they're obviously also concerned about patent owners and ensuring that they're not allowed to use any essential IP to hold a gun to the head of implementers. That's another thing you need to be worried about. And so you need to seek a balance. And seeking that fair balance is the heart of how you set up the regime of a standard setting body. Now, just pausing there, my friends like to portray this as all about protecting implementers. It isn't. It's about being fair to both sides of this, including innovators. And when it comes to it, I'm going to show you that balance is actually written into the ETSI policy. And that balance is at the heart of the proper meaning and effect of the undertaking. To my lady see that the recompense to the innovators is an important part of it, because just consider players operating in that universe of technology. Those that do so are at an unfair competitive advantage. They are at an unfair competitive advantage if they're not contributing to the cost or development of that universe. Or at least if they can avoid paying royalties to the organisations who are investing in the development of it. you only have to consider two handset manufacturers. One, maintaining a team of cutting-edge developers contributing to it, and another just taking the standards once developed and making the handsets and competing for sales in the standard compliant equipment market, all without the additional costs that the first manufacturer has. And it's that issue, the need for balance, which is addressed through the FRAND undertaking given to the standard setting organisation. It's a contractual obligation. In this case, being a mobile phone case, it's an undertaking to ETSI. You've seen, I think, in Lord Kitchen's judgment, clause 6.1 of the ETSI policy set out. It's at paragraph 25 of his judgment. So I'm looking in core bundle 2 on MS 489. You see 6.1 is set out, and the guts of 6.1 is that the innovator informs ETSI of IPR it believes is or may become essential, and it's asked to give a declaration to license on FRAND terms. And just, you see the license, like any other licenses, has to be to do particular acts, manufacturing, sales, and so forth. Just note that, because one of the points I'm going to be making to my lords and my lady is that if you have a patent by patent approach, you can't actually give a permission to do any of those acts unless it's on all of your patents. What's envisaged is that you'll be giving a license to do those acts. And you can see, if we turn up at the same time, core bundle 1, the actual form of the declaration at page 19 of the Statement of Facts and Issues, so that's MS 140. And it's set out about a third of the way down page MS 140. And you see just below the middle of that page, the declaration is given on behalf of the declarant and its affiliates. And I'm going to come back to that point in a minute. You see the very last bit just before the foot of the page, it's a French law obligation. It's common ground that because of that, under French law, it's enforceable under that law by third-party implementers. And you'll have seen Lord Kitchen, so if we can go back to Lord Kitchen's judgment, in paragraph 27, so I'm now just moving a little bit on from where we were before, Lord Kitchen deals with the fact that it's enforceable in paragraph 27 on MS 490, right in the middle of that paragraph. And this is part of his judgment where he's pointing out that the undertaking has international effect, so that the businesses can make and supply the public businesses can make and supply, and the public can use products all over the world. And you see that point in paragraph 26, just above the point that I've just been identifying for my lords and my lady. It's in particular the first few lines of that paragraph. And what Lord Kitchen specifically points to is the effect of part of the policy that declaring just one patent automatically extends to the rest of the family. And I think that's a point that my Lord Hodge picked up on earlier today. It's the middle of paragraph 26. And that means that it applies automatically for a particular invention around the world, because that's what the family generally is. And the rest of the paragraph actually explains that Mr. Cheng again accepted that trying to have undertakings restricted to particular jurisdictions wouldn't make any sense. And actually, in my submission, that's why the undertaking is given in substance by a whole group. Remember, I drew attention just now to the fact that the declarant makes the declaration for itself and its affiliates. Because it's possible in groups of companies to have patents for different territories held in different members. So that's the point of it. It ensures that all patents in the group for an invention are all put in the pot together. And we actually see that particular point reflected in a later paragraph in Lord Kitchen's judgment. It's para 106 on MS 509. He's actually dealing with a point which was put forward in the Court of Appeal but hadn't been a complaint before the trial judge. And I don't understand it to be pursued here either. But you see, some of the patents licence were held by an affiliate. And you see, his lordship says there's nothing in it, and it would be absurd if a group of affiliated companies could game the system by dividing up a portfolio and the undertaking given to Etsy.
But the undertaking is confined to IPRs which are, in fact, essential.
Well, I'm going to come on to that point. That's a point on, in substance, that's a point in re-arguing what the effect of the undertaking is, what is required, and it's the way my friend seeks to say you can have patent by patent. And basically, the answer is, I think, something that my Lady Black is onto. The question is, what are the terms of the licence that have to be offered? And that.
So you say the reference to terms and conditions enables the holder of the patent to make an offer which involves IPRs which are not essential.
Well, actually, it envisages that you're making offers before anybody knows particularly which IPRs are or are not.
You give the undertaking before you know that.
And the licence, the implication
But
is that...
the undertaking, because you give the undertaking in respect of IPRs which may be or may become essential, but the undertaking that you give is to the extent that they are and remain essential.
I understand, and I'm going to come on and deal with that issue, but very broadly, what's envisaged is that you don't have litigation you're trying to avoid litigation.
Yes, but the whole, in an ideal world, the parties reach an agreement. And no doubt, as we know in commercial practice, they reach agreements which concern global portfolios. But if they can't reach agreement, then it has to come to before a court, and unless there's arbitration. And in that context, the question whether there is actually valid IPR, which it has to be valid for there to be a question of infringement and therefore essential.
My Lord, I'm going to come on and deal with that.
I mean, all these issues then become issues which a court, if they're raised, if they're in dispute, a court then has to deal with them.
That depends. One of my main submissions is going to be that assessing the value attributed to a portfolio, the value to a licence, does not involve deciding the validity.
I understand that, but the licence has to relate to patents or other, I suppose they're going to be patents, which are valid and essential.
It definitely has to relate to them, but that doesn't mean that it has to be limited to them because you don't know what they all are in advance. If you were to litigate one, really this is a timing point, and one of the things that I'm going to show, my lords and my lady, is that it is considered illegitimate to predicate entering into a licence on determination first of validity and infringement. It's absolutely clear, and we'll see that in the Advocate General in Huawei and ZTE. We'll actually see it, I think, in Huawei's own documents. And what this is another way of putting that timing point. Because what my friend is saying is that I don't have to enter into any licence until you've sued me, and because it has to be essential, you can't do that if I dispute it until I get to the end. And that's not the way it works. What is the right test is what are the FRAND terms that have to be offered. My friend accepts that he can enforce it against me for every single patent. And what he wants is an imbalance. He wants to be able to say, I can pick and choose, because on the timing issue, it may turn out later that one of them might not be. And I was going to show you,
Very well.
again, just to show you where I'm going, that's actually all priced into a license.
Yeah.
That's priced in because you're taking a license on a portfolio. No,
Yes, I
say
understand
you take 1,000 or whatever, you know it's going to happen.
Mr. Speck, when you get to the nitty-gritty, it would help also if you could explain how the definition of family leads to what I think is the common understanding of what family means. I think the common understanding, it means every patent in any country which protects the same invention. Yeah. But the definition doesn't seem quite to say that, and no doubt at some stage. Don't choose your time.
Well,
I just wonder how, in fact, it does. It talks about priority.
The definition ties it into priority dates, but I assume it's talking about the same invention.
Well, let me explain very quickly. Some of you may remember from earlier cases that the issue of priority is sometimes important in a patent action. And that's because you have a system whereby instead of having to file all around the world on the same day, you have a system where you're able to file one application in one country and you have a year within which to file others. And you get your date from that priority document. And so within the year, you file all around the world elsewhere. And they all have the same priority document. Under the PCT, they claim priority back to that first application, and that's why my Lord's quite right that we're standing here before my Lord on the basis of a common understanding that one family means the same invention all round the world. It's all of those national patents that have been filed in that year period, usually just cutting and pasting the description of the invention in the priority document. When they don't quite, you get into issues as to whether they're entitled to priority.
Yeah, but what's being argued against you is that you have to look at it country by country, individual patent by individual patent, in case a court somewhere else said, oh, there's added matter there, where another court has said it's okay.
I understand that.
That seems to be the argument that's being advanced against him. You say that is inconsistent with the whole thrust of ETSI.
Yeah, it's inconsistent with the whole thing, and it's also inconsistent with the fact that you're on the hook, as it were, every time you declare a single document, all of those national documents that I've just explained, you can choose to declare any one of them, and it's deemed to apply to all of them.
Yes.
Before we move further, can I briefly make sure we're very clear about some of the labels that we use? Firstly, a point that my friend was very keen on in his printed case was to say that SEP should be restricted to meaning something which truly is or has been determined to be valid and essential. That is one way you could use the term. And he was very upset in the way the term had been used in the courts below, because it was being used in a much more common way, actually, to mean those patents which the owner considers to be essential. And it's used in that context as a contradistinction between non-SEPs or implementation patents, meaning those that may be to do with mobile phones but are not to do with what they say is essential. And the reason it's much more common to use it in that term, in that sense, is because you don't often actually have litigation where it's been determined. And so usually commercial people are talking to each other about whether they will take a license on this portfolio of patents. They call them SEPs because that's the way they're treating them. And they might sometimes say, and you want this other portfolio of non-SEPs, meaning an implementation patent. So that's a different way in which the same term is used, and it doesn't matter as long as you understand the context. Another categorization that I want to make sure you've understood is the different types of licenses, because again, my friend muddled the term, or used the term, a license for worldwide royalties. And I'll be a little bit careful about what he means. So I want to explain what we mean when I'm going to use particular terms. The first category is a global license. And the point about that is it deals with the world in one transaction. The royalties payable don't need to be the same for sales made everywhere. Indeed, you can have a global license which actually might specifically provide that the royalty rate is 0 for somewhere. It's still within what I mean by a global license. It's a single transaction that deals with everywhere. And it certainly can have different rates applicable to different places. And that's what Mr. Justice Burst did here, different rates to different places. The next is what I've already foreshadowed as country by country. And that is a structure where the parties have to negotiate and, if possible, if necessary, litigate separately country by country. What it means is that a particular device or piece of kit will be licensed, say, under a UK-only licence, but not for other countries. And securing a licence for one country does nothing to resolve the position as regards sales or other activities in other territories. They remain unlicensed. And you don't get any royalties in respect of them if you're the patent owner. Now that country by country approach not only is inefficient and causes a real problem recognised by Lord Kitchener, but it actually gives rise to problems as to the legality of the products. First of all, goods parallel imported means that goods that come in that are sold in another country are not actually licensed for here. But it also gives rise to the roaming issue, which I think you'll have seen mentioned, where users go somewhere else and use their phone. So if you consider all the businessmen and women that come into the United Kingdom with a device, if they're licensed on a country-by-country basis, even if they come from a country where there is a licence, they're not licensed for here. And it's a problem the other way round. It means that the phones that are sold here to you and me are not actually licensed for us to use anywhere else.
But does, oh yes, because the 6.1 undertaking includes use and operation, not just sale and repair and manufacture. Yeah.
It's a problem. It's a legal problem, if I can put it this way, in that if we as lawyers sat down and said, what licence do you need? We'd actually say, you need a worldwide licence for every phone. It's not a problem for those on the other side of the court because they don't care. If you can practically sell a phone to somebody and they wander around the world with it, and they don't have to pay, they don't want to pay. Can I just on this categorisation say this? Huawei, when they talk about a licence for worldwide royalties, they're actually talking about a single country arrangement. They're talking about a China-only licence because they happen to manufacture their phones in China. But they will be unlicensed for sale or use outside of China. Now, the third and final category is precisely the thing that I understand the logic of their argument is going to, which is patent by patent. So you don't even get a license country by country. You have to negotiate and litigate each patent separately. So both in each country and then within each country, each patent separately. So you have to secure a judgment or negotiate a license on each patent. And I want...
Or it might be each patent family.
well, if it's each patent family, it's global.
Yes.
Yes, I mean, it is global to the extent that there are patents in many jurisdictions.
Exactly.
Yeah.
Yes.
Exactly. There might be... when I say
It's
global...
international rather than
Exactly,
global.
it's international. There might be... Well, on my definition of global, you might provide for particular countries where there's no coverage for no royalty. That's still...
Yes, yes.
Depends where the manufacture and so on happens. But if you did it for each patent family, and Lord Hodge is right...
Yes. I mean, it's global in one sense. It's not in the sense of a global portfolio of claimed IPR rights, but global in the sense that it's international. Yeah. And there's then, on that approach, there's then an issue about how a national jurisdiction then deals with the issues that then arise. But just in terms of how you interpret clause 6.1, that's the possible reading when you take it with 6.2.
I understand what my Lord's putting to me. I say it's not the right one, but it's certainly a better one than my friend's. But I want to make sure...
I mean, he's not saying you have to negotiate patent by patent, but I think he is saying you must negotiate by reference to those patents for which the implementer actually asks for a license.
Yeah, but the reality is that they're not going to ask unless you sue them and they're looking down the barrel of losing. The reality is that's what he's talking about. But you're quite right. Within what he's saying is that he could knock on my door and say, I really want to give you some money for this patent. Negotiate a license. But that's not the reality of what's going to happen. His system is that he can pick them off one by one.
Yes, and the oddity is you can have one invention which the inventor has established is inventive. It meets all the definitions of a patent in one country. And although you are obliged to offer the whole family, he can say, well, look, I'm just taking that one country, and you've got to sue in X, Y, and Z to prove that the wording of the patent is sufficient to give the protection within that jurisdiction of that admitted invention. And you're saying Etsy shifts the onus?
Etsy sets up a system where they anticipate that you enter into a license rapidly, and it actually allows you to come back. And if it's a good point, I've already foreshadowed to my little lady that actually the fact that some of them might turn out to be invalid or not infringed is priced in. But if there are some specific points about specific patents or territories where it makes sense to have a go at them, you can do that afterwards, and I'll show you that it's envisaged that you can reserve the right to do it, but you can't hold up the license. What it's about is giving you prompt access, fair access to this universe of technology that others have invested heavily in, and where's the onus in terms of showing that the other family members are also invalid or valid, or that it matters. Because we are talking about portfolios which are, as I say, on the whole, very, very substantial, some of them absolutely enormous. So showing that 1, 2, 10, or whatever, however many it is, are invalid, if the license is over 1,000 of them, that's all priced in. But the approach my friend takes is to say, well, I want to be able to say they're all invalid, and the onus is on you to make out your case that I have to pay for them. That's what it's all about. Just onus. And that's why, actually, it's quite important that in the real world, that's not the way people look at things. And that's why I'm going to be saying to my lord and my lady, that valuing that permission doesn't involve actually looking at any specific patent. That's one of the fallacies in my friend's argument, that it actually involves determining that these particular patents are valid and infringed. It doesn't. Now, I don't think I've quite finished the point that patent by patent comes in two flavours. I foreshadowed this already because one involves an actual licence. That's his patent by patent under the ETSI undertaking. But his damages in lieu of an injunction is patent by patent with no licence at all. Just to flag up, we need to keep an eye on that. Can I move on to say a word about the practical realities of patent litigation in standards cases? You've already got a bit of a flavour of what I'm going to say about this. In ordinary
Sorry, when you say that none of the patents need be valid or infringed, you're relying again on your timing point to overcome the reference to essential in 6.1. Are you?
I just said none of the patents would be licensed.
Yes.
That's in his argument that there should be damages in lieu of an injunction.
Yes.
So there never is a license, and in fact licenses deal with other things than royalties, but there's never a document headed license that they sign with obligations on giving information and audit rights and things like that, and obligations on my side to consent. So there's never things that have impacts on matters such as exhaustion of rights, where there's a consent and I promise not to sue customers, or it's implicit. There's never a license. What is second flavour of patent by patent is that you just sue, the patent owner never consents, you never enter into a license, but all you get is an order for damages.
Yeah. And your argument is that the license covers many other things than simply the monetary sum, and therefore the argument that an injunction isn't available if damages themselves is an adequate remedy doesn't bite your case because you get benefits from the license.
Well, that's part of my argument,
Yeah.
But actually, I've got a broader point on that, but my lord's absolutely right, that's part of my argument. And at this stage, I'm just flagging up a feature,
Yes, of course.
of what he is saying, so that you
I think just
understand.
before that, you said that it doesn't involve looking at a particular patent and that none needed to be, I can't remember what the words were, valid and infringed or something of that sort. I think that's what maybe my Lord was asking.
Yes, it was.
about.
Yeah.
It depends on showing a particular patent is valid, is how I noted you.
Yeah, I'll go back to that. Was a slightly earlier point that I was making.
Yes.
Sorry, I've galloped ahead a bit. I did say that valuing a license, valuing the price for the portfolio, whatever's being licensed, does not involve determining any specific patent within it is valid and infringed. And I think, if I can recall what my Lord put, it does come back to my timing point as well. They're conceptually a different thing. And I'm actually going to come on, when I said to my lords and my ladies, I've got a handful of things that I'm calling propositions. One of them, and I'm now jumping ahead, is that the payment of a royalty under a license is not the same thing as the payment of damages for infringement of a specific patent. Conceptually different things. Now, can I just say a little bit of a word about the practical realities in patent litigation and contrast standards cases with ordinary cases And there's a very big difference in the dynamic. In ordinary cases, we don't have these huge numbers of inventions all converging, but we have the odd individual patent that in fact prudent traders are seeking to avoid. And these are cases where if there's no deal agreed for a license, a successful patent owner simply gets an injunction and the infringement stops. And so if you have a decision in one jurisdiction or perhaps a couple, you rapidly lead to a resolution of the dispute. For standard essential patents, it's completely different. And one of the things that you heard from my learned friend Mr. Block was a suggestion that actually, if you just allowed a litigation in one country or maybe two, that it would all be settled. That's not so. For a start, we're talking about huge numbers of inventions and patents, as I've explained. We're talking about parties who both say that they're willing to take or provide a FRAND license. Whether or not that's true, they say it. And we're in the context where the number of patents is a very important part of assessment of that value. Not only it, but the number is a very important part. So an implementer will do the usual of denying infringement and challenging validity if they're sued. But they also enforce the patent owner's ETSI FRAND obligation. They say, I want the FRAND license, please. Or at least they say it. Although cases like TQ Delta show that when it comes to it, they may say it all the way to judgment, but then change their mind. But the dynamic is thus. Whilst the litigation trundles on, the implementer purports to enforce the FRAND undertaking. But what they really want to do is to avoid having the content of that obligation determined. Why? Because they're actually enforcing it by just saying it. And they're enforcing it for free at that point. So the dynamic is that they want to avoid resolution. And if the licenses can be split up, patent by patent or country by country, for them it's good. Because it means that when they run out of ways to secure delay, they can limit what they actually have to pay for to just a small part if it ever gets resolved. There's individual patent if it's a patent by patent argument, or just one country, and the rest remains delayed. And there's certainly no incentive, which was inherent in my learned friend Mr. Block's submission, to pay for the rest when they actually get trying to think of a polite way, when they're actually found that they have to pay for a patent or an individual country. So there's no incentive to say, well, you've got me in this country, I better divvy up for the rest of the world. Absolutely none at all. And that leads me to the practical issue of hold out and hold up. And they're two phenomena referred to in these cases, and you'll have seen Lord Kitchen identified them both in paragraph 5. This is MS 485. And what they both relate to are parties claiming that they're willing to conclude a FRAND licence, but complaining that the other side won't agree with what they say is FRAND. And at the heart of each of them is that dispute over what the FRAND obligation requires. Hold up is a complaint that implementers make. They complain that they might be compelled to accept more onerous terms than is truly FRAND. And they say it arises because of a perceived risk of being injuncted excluding them from the market before the dispute over what is FRAND has been determined. And that last thing is very important. What they're worried about is, while there's a dispute over FRAND, there's a risk they get enjoined anyway. There are some jurisdictions where that could happen. Not here.
Your point is validity and essentiality in the UK system has to predate the determination.
Mr. Justice
Of the
Burr said very
injunction.
clearly
Yes.
that an injunction, both when there's a patent that's valid and infringed there is a patent that's valid and being infringed, and a FRAND licence is available. So the point is, it can't happen here in the procedure that's been adopted here, because there is no risk of an injunction before the FRAND dispute has been determined. Holdout is conduct where implementers just go ahead and use the standards. They can do this easily because it's in the information that's published by the standard setting bodies. And what they do is what I've foreshadowed earlier, is they avoid taking the FRAND licence for as long as possible. And it's attractive because the sums at stake are usually huge. And as my lords and my lady know, capital itself has a cost. So if you can avoid, or at least delay paying, even if you're spending money on lawyers defending litigation, it may be money well spent. And it's all the more attractive if one can simultaneously enforce the FRAND undertaking, but delay or avoid having its content determined. Because then, as I've said, you avoid both the patent enforcement and paying under the disputed FRAND licence. And as I think you'll have gathered, holdout everywhere is a good thing, but if you can't do that, doing it patent by patent or country by country is also a very sensible strategy for somebody in an implementer's position. And I think you'll have seen that holdout is something that Huawei's own expert actually had shown is a real thing. Implementers are under an economic incentive to defend cases to end up with lower royalties than FRAND. I don't ask you to turn it up now, but it's referred to in the judgment of Mr. Justice Burse, paragraph 96, MS 661 to 662. Now, my friends seek to suggest that holdout is not a serious issue. Certainly the substance of the points made at paragraph 90 of Huawei's printed case. And I think they go so far as to say they wouldn't dream of it. Now, as to that, just a couple of points I draw attention to. First, and perhaps the bigger point of substance, is that many will, even if Huawei's intentions are entirely honourable. Second, Mr. Justice Henry Carr has already concluded that they do pursue that course of conduct. That's the finding we draw attention to at the foot of MS 330 in our printed case. I'm not drawing attention to that to vilify them. As I've explained, the sums at stake are huge, and there is an economic incentive to do it. And if there is, people will do it. And in a similar vein, I remind you that they maintain the stance right to the door of the court, patent by patent, which actually, through their witness, accepted was unreasonable. My learned friend will no doubt explain to you, when you ask him in his reply, why wasn't that holdout? I also say, you can ask him why arguing for a approach, country by country, one that Mr. Cheng accepts results in impossibly high costs, is not holdout. That's what this is all about. Avoid what ETSI has done to onus, you can hold out. Now, can I move on in the 5 minutes that's left to me today to the straightforward answers to issue 1? Because I want to try and bring it back to the actual issues in the case, because the issues in the case, as agreed, issue 1 and 2 that I'm dealing with, are to do with, well, let's have a look at issue 1, because it's not actually anything to do with re-arguing the proper meaning and effect of the ETSI-FRAND undertaking. I mean, the Statement of Facts and Issues, Core 1, MS 123, it's in actually 2 parts. Part A is as to the granting of an injunction to restrain infringement. It's the injunction to restrain infringement where there's a global FRAND license on offer as the alternative. And the court obviously has jurisdiction to restrain infringement of patents that are UK patents. The restraint only applies to activities in the United Kingdom, and it's only enforcement of the United Kingdom patent. Moreover, I say this: the court may properly grant such an injunction where the patent is a standard essential patent if a license on FRAND terms is available. The court may properly grant such an injunction if a license on FRAND terms is available. That is the correct and principled approach, and it does not cease to be so when the FRAND license required from the patent owner under its obligation to be global. The way in which the injunction is actually tied to that license is that it's limited by wording that it shall cease when Huawei enters the settled license. And settled license is the label for the FRAND terms. I don't ask you to turn it up, but I do ask you to look at it in due course. It's at Core Volume 2, page MS 585, and it's paragraph 4. It's simply an ordinary injunction which comes to an end if the FRAND license that is available to them is entered into. It's a limitation on the injunction. Put bluntly, the patent owner is getting less than an ordinary injunction, so it's difficult to see why it's improper. And moreover, I say this: the injunction thus framed specifically gives effect to the ETSI-FRAND undertaking. It is basically holding the patent owner to its undertaking to offer a FRAND license and gives the implementer the option of access to the standard by taking that license that the patent owner has undertaken to make available. So that is the short answer to Lim 1. I think I can deal with the short answer to Lim 2 very quickly as well.
Well, there's perhaps a slightly longer answer. That whether it's a proper exercise of any such power will depend on the application of ordinary principles on which equitable injunctions are granted.
Indeed. But what I say to you is that it is proper where what you're doing is giving effect to the ETSI-FRAND undertaking. You're holding the patent owner to it. second limb, determining the royalty rates and other terms, the defendant is enforcing a contractual obligation against the patent owner, claiming it's failed to offer a licence on FRAND terms, and it's seeking the benefit of that licence. There's no issue here as to subject matter jurisdiction at all. It's a French law contract that's being enforced. Nor, in my submission, is there any issue with the court properly exercising that jurisdiction. The issues arise because the patent owner has sued on its United Kingdom patents, and the implementer is seeking to enforce that obligation against it. And actually determining the terms is a factual exercise, seeking to value the licence. As I've already foreshadowed to my lords and my lady, it is not and does not involve the adjudication of validity or infringement of any SEPs. I've got to a point where I was going to move on to my 13 or 14 high-level points.
And can I be clear how you put the relevance of the undertaking? I had thought from reading Mr. Justice Burse's judgment that the way the matter was put was that your clients could not obtain an injunction unless they complied with the ETSI undertaking, because obtaining the injunction would be an abuse of a dominant position under EU competition law. Now, nobody has made anything of that. So it's put on the basis that the breach of the undertaking given under French law would disable the claimants from obtaining an injunction under English law.
It could actually be put as a counterclaim for what it is it's saying, you have to offer me FRAND and you haven't, and I want the FRAND, implicit in all of this is I want the FRAND licence. And we're going to see some foreign cases tomorrow where people say that, and then when they're asked, do you really want it, they don't always mean it. But that's the way it's put as a contractual defence. You're required to offer me a FRAND licence, and you haven't.
Yes.
It's a defence to the injunction, my lord.
Yeah.
Yes, I understand. Thank you.
That's my lord. Have any other questions?
I think not. In that case, we'll adjourn now and resume at 10:30 tomorrow.